Dr. Sarah Birete, the Executive Director of Center for Constitutional Governance, has this Wednesday appeared at Buganda Road Chief Magistrate's Court to hear a bail application. The prosecution urged that for proposed sureties lacked proof of sufficient income and property to guarantee her bail.
Your Worship, in the case of Tiga Bakari, which is criminal case number 0161 of 2023, criminal case number 0161 of 2023. Your Worship, in this case, the High Court declined to grant bail on the ground that the applicant in the case had not satisfied court that the illness they were complaining about was incapable of being treated in the prison, in prison custody. That the applicant had not adduced evidence to the satisfaction of court that he is suffering from such great illness which cannot be treated in the prison service, medical service. Also, in the case of Muvera John, it's a miscellaneous application number 21 of 2023. Actually, court denied bail in this case on the basis that the prisons had confirmed that they can't manage the illness of the applicant. Your Worship, rely on medical grounds as for the grant of bail. This must be true. There must be evidence that the prisons cannot manage the illness or the medical condition of the applicant, which has not been proved in this case. And it's our prayer that this ground should not be relied on for the grant of bail. Your Worship, viewing the application by the defense, that bond, or at least provide proof that they can furnish that bond. Your Worship, still in the case of Agamia Albert, it is mentioned subsequently that proof of substantiality of the surety calls for documentary evidence of facts to prove capacity to meet monetary obligations. And court went on to give an example that proof of ownership of property can be attached and sold is that of the proof of evidential value. Your Worship, it is not a joke that we come and stand surety when we cannot afford to forfeit a bond. Also, in the two cases, they are distinguished. Both of Mugera John, but different applications. 002 of 2022 different application and 021 of 2023. Both those cases indicate that sureties should have some credible source of income. It is not fair to tie a rope of being surety around the neck someone who is not having the capacity to create a bond in the event of abscondment.
The defense led by lawyer Judy Biamukama urged the court to respect the presumption of innocence and grant the accused bail.
That reference, DPP versus Cabinet Constitutional Reference 20 of 2005. It emphasizes that the key criteria, the question that the court should be asking itself is, will this accused person abscond if she's on bail? Is she going to run away? Or is she available for trial? And the others are irrelevant considerations. That is why the Constitutional Court in another matter, Foundation for Human Rights Initiative versus Attorney General, the Constitutional Court, again unanimously pointed out that even the bail requirements in the Magistrates Courts Act and the Trial Indictment Act are guidelines. It's not mandatory that they should exist for an accused person to be granted bail. Why? Because there is a presumption of innocence. What is the interest of the court with an accused person? The interest is that the accused person able present herself for trial. That is all. These other sentiments that the state brings must have evidence. The learned prosecutor is advancing a theory that the accused person is a person of substantial means, that we can all recognize it. Of course, that is speculation. And funny enough, the same learned prosecutor thinks a former leader of opposition, a former chief whip in parliament, a member of parliament for over 10 years, is not a substantial person. Your Honor, we can't take that as a serious submission. Your Honor, return to the guide, the bail guide.
After hearing submissions from both sides, Magistrate Winnie Nancha Jatiko remanded Dr. Sarah Birete to Ruzilla Government Prison until 28 January 2026, when the court will rule on her bail application. Dr. Sarah Birete was arrested earlier this month and charged with unlawfully obtaining and disclosure of personal data, another Data Protection and Privacy Act. Prosecution alleges that Birete, together with others still at large, unlawfully accessed national voter information between January and December 2025 across Kampala, Mukono and Wakiso district without the Electoral Commission's consent. Sarah Birete pleaded not guilty to the alleged offences.